I'm ringing in relation to a subject access request I made with West Yorkshire Police. It's one where you had looked into it and had upheld my complaint that they were asking for a lot of documentations.
Right.
And I'm just looking to chase this up with yourself.
Okay. Could I just ask your name? Is it Mr. Hussain?
Yes, that's correct. Yes.
Oh, right. I thought.
You got good memory.
Were you acting on behalf of your brother?
Yeah, you got an excellent memory. I'm very impressed.
I don't know why. It just stuck in my mind for some reason because I seem to remember. If my memory serves me correct, do you have a power of attorney or something for your brother?
Yeah, a lasting power of attorney. That's correct. Yes.
Yeah. And I'd actually said to them that because they'd identified you correctly, the lasting power of attorney was sufficient for you then to act on behalf of your brother.
That's correct, yes. And you had written off to them and they had accordingly changed their policies. That's correct, yes?
Right, I can't remember.
Yeah, I mean, obviously that case is closed with. But the purpose of my call today is I'm making a different subject access request with the Ministry of Justice. And once again, I'm finding myself in a situation where, rather than, they've identified who I am, but they're asking for an exorbitant amount of information that I personally don't feel very comfortable with disclosing. Now, my understanding is that, for example, if I go to an organization and I give my name and address, and then a case is opened in my for myself in order for me to procure some services, let's just say from an arbitrary organization. Then once it comes to making subject access request, it seems that they're utilizing the level of identification that I would require in order to open up a bank account, which is normally, in order for me to open up a bank account, it has to be a far more stringent process. And normally when I go open up a bank account, they say we need two forms of identification. One has to be photographic identification or a utility bill within the last 3 months. Now, I don't mind doing that to open up a bank account, but I do take issue or it concerns me greatly where if I've gone to an organization and I've given them limited information, they then turn around saying we need to identify you and ask for further information that I potentially they would not have. And so I'm finding myself back at that situation again, where although you've upheld my issue with West Yorkshire Police, when I'm going to the Ministry of Justice, they are now equally well. Actually, I'm going to the Office of the Public Guardian, who have directed me to the Ministry of Justice to make a subject access request, and once again, I feel very uncomfortable with giving my basically driving license over in order to get information, and that creates a situation where they are now holding excess data that they wouldn't otherwise. And I feel I'm being slightly discriminated against or prejudiced against because, for example, if you were to be a service user of this organization, they would not potentially have extra information about you. But in order for me to make a subject access request, I have to hand over excessive information. And I don't think that's right, and that's one of the reasons I've contacted yourself, because obviously you have upheld my previous complaint issue with the West Yorkshire Police, and I think it was the right decision, and they have accordingly rectified that problem. But that is an isolated incident. When I've gone to another organisation such as the Ministry of Justice, they're once again asking for excessive amount of information. So the reason for me calling you today is to say that can you direct me to any literature that says that they're within the right to identify me, but they don't have a right to ask for information that they wouldn't otherwise hold about me.
Well, right. We don't really have any safety cases at the moment because the new legislation is relatively young. I can direct you to the articles where it kind of points when they should ask for identification data and what the limitations of that should be, which is what based my decision on for the West Yorkshire case. And we look at each case on a case-by-case basis. So I can give you some of the quotes you will give to go back to the Ministry of Justice and see whether you can persuade them to waive some of the requests if you feel they're onerous. But ultimately, if they then refuse to do it, you'd have to come to us if you wanted a decision. But Article 11
Okay.
is about processing which does not require identification, it says. And it says if the purposes for which a controller processes personal data do not or do no longer require the identification of data subject by the controller should be obliged to maintain, acquire, possess additional information in order to identify the data subject for the sole purpose of complying with this regulation. When in cases referred to in paragraph 1 of this article, the controller is able to demonstrate that it's not in a position to identify the data subject, the controller should inform the data subject accordingly, if possible. In such cases, Articles 15, which is the data subject access request, shall not apply except where the data subject, for the purpose of exercising his or her rights under those articles, provides additional information enabling his or her identification. So that's what it says. They can ask for it for identification. But if you look at Article 12.6, it says, without prejudice to Article 11, which is the one where they can ask for data, where the controller has reasonable doubts concerning the identity of the natural person making the request referred to in Article 15, the controller may request the provision of additional information necessary to confirm the identity. So, therefore, the controller has to have reasonable doubts as to your identity.
Okay.
And then they can ask for the necessary information to confirm your identity.
Okay.
So it's kind of a bit woolly, really. When I read all the circumstances of you and your brother's case, it was quite clear because they dealt with previous subject access requests using the same emails. And I think they'd even confirmed in a letter that they knew who you were.
Yes.
Then you had actually given the power of attorney documentation or copies of it to them to prove that you could act on your brother's behalf.
Yes.
And they were wanting, did they want data about your brother? And my viewpoint was, no, it was you, because you would actually effectively make the request and they knew who you were to get on and give it.
That's right, yes.
That decision. So, without seeing all the circumstances around the Ministry of Justice, I can't make a decision. I wouldn't be able to make a decision on it. You'd need to submit your complaint form and go through the whole rigmarole, I'm afraid.
Okay. Yeah, I know. It's just one of the reasons I've contacted you, because as you know, if I put a complaint in, under normal circumstances, pre-COVID, it was a turnaround of 3 months. And now, as you can appreciate, because of the COVID situation, the turnaround could be a minimum 3 months.
Yeah, we are actually still running around about 3 months behind.
Yeah. So I just have to take that into consideration primarily, and secondly, actually, it's not the Ministry of Justice that I'm making a subject access request to now. Can you just help me clarify the situation, because I actually made a subject access request to the Office of the Public Guardian. Now, my understanding from all the literature and everything else, the Office of the Public Guardian is an organization. I had assumed that they as an organization would be registered with yourself. And like under normal circumstances, like let's say, for example, a member of parliament has an office, and I as a constituent go to that office to make inquiries and my data is collected. Under those circumstances, my understanding is that the member of parliament itself is a data controller, and they have an office that they operate under, and that seems quite right. But under the circumstances of the public guardian, he also has an office. He's appointed by a minister of justice, and he has an office. And obviously, I've been liaising with the public guardian's office, and so I directed my subject access request to the Office of the Public Guardian. I then found that it was bounced to the Ministry of Justice, and I thought, well, that doesn't seem right, because I've not been dealing with the Ministry of Justice. I've been dealing with the Office of the Public Guardian, and I had presumed the data controller would be the Public Guardian himself, just like, for example, like an MP's office, and the MP is the data controller. But upon further inquiries, I've discovered that actually the Office of the Public Guardian is an executive agency of the Ministry of Justice. And so, therefore, under those circumstances, the data controller is the Ministry of Justice. Now, that doesn't sit right with me, because it gives an avenue where executive agencies potentially don't need to register with yourself, yet they are operating and acting as quite independent organizations.
Well, there's quite a lot of organisations that kind of act in that sort of fashion, and I know that the Ministry of Justice has centralised a lot of their data protection stuff under kind of one. I mean, I think there seems to be quite a few officers that help deal with it all, but they do have one kind of central office to deal with all data protection issues.
Okay.
But I don't think there's anything particularly remarkable about that. And I could give you an analogy as well, whereby lots of large businesses, historically, they might have had a number of subgroups to the business, and each one of them was used to be registered with us prior to them having to pay fees. And what they've now done, because it's all one big business with subgroups,
Yep.
generally set up one data protection office to cover the all the sister partnership organisations to deal with everything, and by doing that, they only have to pay one fee.
Yeah, I understand. I understand. I mean, that's a very good analogy that you've given. Like, for example, they have subsidiary companies that have completely different names. Like for example, Google is owned by Alphabet Inc. And Alphabet Inc. owns a lot of other corporations. I think under those circumstances, this is a decision that obviously yourselves have made as the ICO, that because they're all part of one big conglomerate, that only the head organization needs to register with yourself and not the individual organizations. That's a decision that yourselves have made. But in the analogy that you've given, the subgroups are basically one legal entity, though. I mean, so they're part of the same legal entity. So if we talk about legal entities, my understanding was that the office of the public guardian, the public guardian was a separate legal entity, and so therefore it's not quite the same analogy as the ones that you've given, because the analogy that you've given is like a business analogy where the subgroups. But this is where if I'm making a subject access request, I don't make it to the UK government. The UK government is broken down into different departments. So the analogy that you've given, where in the business realm, many conglomerates choose to register once with yourself, even though they have many subsidiaries. But that analogy breaks down when you're talking about the government, because the government, obviously, as the example that I've gave, it's not the UK government that deals with the subject access request. It's each individual member of parliament, or because they have an office, and so this is where I'm struggling with the analogy.
All right. Well, I mean, I'm just trying to. I wouldn't overly worry about the analogy. What I'm saying is it doesn't surprise me the fact that that group is using the Ministry of Justice to provide the responses for any data subject requests.
Okay. And so let's just move on from this now. Yeah, so that doesn't surprise you that you're saying that even though it's not straightforward, it's not unusual, because it can happen at times where the data controller can be separate from the actual organization that's running it due to cost savings or efficiencies. Okay, so I don't have an issue with that. Let's just move on from this. The issue that I have is that, as you can appreciate, the Ministry of Justice is the senior department in the UK, obviously because it deals with justice, and for them to have a policy where they've, when we've just talked now, you've mentioned to me legislation on where there are circumstances where an organization feels that they haven't correctly identified somebody, that they ask for further information. Now but the reality is that the Ministry of Justice have the policies that they have in place are just general. So that anybody who makes a request to the Ministry of Justice, they ask for two pieces of data, which, as I mentioned, is like either a 3-month utility bill or a driving license. So that would not be information that they would hold ordinarily.
Well, I mean, they have two problems, organisations, when they come in to deal with things where they're going to have to subject access requests, especially when personal data is going to be sent out.
Okay.
And the reason, if they have a reasonable doubt, they're duty bound to actually do checks, because if they were to send the data out to the wrong party,
yes,
in they can be liable to
Yes.
breach of that data.
I know, I perfectly understand that, and obviously those mechanisms are there to safeguard members of the public. But these are just some of the issues that I've come through because, as I've explained, if I go to my member of parliament, let's just say as an analogy, and I ask him to take on my case, and I'm providing him with some information. For example, I mention my family members, and I mention, I need your assistance in this. I give them the names of my family members. Now, that is all data that gets recorded by the at the constituency office of the member of parliament. I then turn around and say I would like to make a subject access request, and this is who I am. And it can also be utilized as a stalling technique as well, and that's what I'm worried about. When the member of parliament can turn around and say to me, well, I need 2 proofs of identification, 3 months of utility bill, and a driving license. In order to dissuade me from making a subject access request, because that is not information that they hold. I then proceed, I say, okay, well, you know who I am, but let's just say for argument's sake that you want this information. I think that I consider that's excessive to identify me, because I've obviously been liaising with yourself. But I provide this information, and then the information I get back on the case file is that the names I've given of my family members or relatives or natural people that I've mentioned are redacted. Now, can you just clarify this to me? Because if I'm the party that's giving the information and I make a subject access request to get that information back, then are they within their rights to redact information of natural people's names that I've given?
I mean, I would suggest that it's fairly ridiculous to do that when you provide the information in the first instance, because they're meant to do a 3-part assessment as to whether they provide third-party data in response to a subject access request.
Yes.
Bottom line is through that 3-part check is there going to be any threats to the rights of the third-party data?
Yes.
You've actually provided the information in the first place. I can't really see what threat there is to the third parties, so it's just absurd for them.
Okay, yeah. I mean, I've come across this as well, and I concur with yourself. If I'm the one that's providing the information, then because this is new legislation, people are just looking to find ways to come out of the situation, and that can't be a grounds to say, redact names that I've given. So that's the first point. The second point is that, if I, for example, in this analogy that I'm giving yourself, let's say I deal with a caseworker at the MP's office. Let's say their name is Joe Bloggs. Now, they take down notes of my sessions with them. When I make a subject access request, because Joe Bloggs is also a natural person, are they within their rights to redact his name as well? And the question is that people that work in an organization that are dealing with their everyday business activity, when I make a subject access request, can it be utilized that is a natural person and therefore we're going to redact his name?
They can do. Again, they just have to do that assessment to make a decision. And to be quite honest, even if we were to find against them and say we don't think that sounds reasonable, they could still refuse to do it on the basis that they feel their assessment is correct. And we'd end up saying you'd need to go to court to get a court order if you wanted that additional data. That's where we'd end up with in terms of a pragmatic outcome in relation to your complaints. But what we're actually setting out in our letters to you is our opinion. The actual document I send you doesn't actually have legal status, but the court may well take it into account on the basis that we're the regulator.
Yes, I understand this. I mean, obviously, as you can appreciate, I don't want to go down the court route simply because of the time, money and resources in order to get information, so it's something that it's a very last resort, and quite rightly it should be, because it shouldn't be a frivolous process where I'm taking people to court for arbitrary rulings and stuff. But so it's something that I'm looking to avoid, because obviously if I'm getting the information back that should be supplied to me, I don't have an issue. It just concerns me where, when an organization receives a subject access request, their first protocol is to find exemptions or ways around, dealing with a straightforward matter, which then means that I need to then elevate this to yourself, which takes up more time and resources of your organization, which is unnecessary. And like, for example, the purpose of my call today, you've already dealt with the situation, and one of the reasons I'm calling yourself up is because obviously you're familiar with this validation process, only to find that I'm faced with the same situation now with a different organization, and there's no place that I can direct them at your website that says, look, this is what should happen, is that if the person is providing you with limited information, then it's that limited information that you need to identify the person. For example, if I ring up a call center and I give them my name and address and date of birth, and they record that on a call center, I then make a subject access request and just provide that limited information. That should be adequate, rather than for them to turn around and say, no, we're going to now, put an extreme level where you need to find providers with documentary evidence of who you are.
Well, it's very hard for me to come out with a definitive answer for you or give you advice in relation to that, because the term within the regulations is reasonable doubts, and which is a fairly subjective term, I'll suggest.
Yes, it is. Yes.
And so, what's reasonable doubt to one person might not be to another. I think the other thing, when I'm looking at each case on a case-by-case basis, I sometimes look at the type of data that's being asked for, and the more sensitive or amount of special category data that might be in that response, I think the more careful we would expect the data controls to be when identifying the individual. I don't know what information you're asking from the Ministry of Justice, but again, I might actually say, agree with them to ask for some additional identification subject to what they might be passing out, because if they give it to the wrong person, it has a very big impact on a person's life if they get it wrong.
Yes.
You see what I mean? So a lot of this is kind of quite a subjective judgment you have to make based on all the circumstances.
Yeah, I can understand the subjective judgment that you're saying, like reasonable doubt, but my perspective is not that. My perspective is that obviously my view is that my personal data is my intangible property. And so therefore, in order, I don't want to give my number out, my name out, my address. Under normal course of events, don't want to give any of my information out, my name, my address. I don't want people to see what I look like. I want to have my privacy and anonymity. That's what's afforded to me as a citizen. But the reality is that if I want that, I shouldn't get out of my house. But the reality is that in order for me to procure services, I do need to, engage with the organization. So the information that I'm looking to give out is on a very limited basis in order for me to procure goods and services. All right. So I can't sit at home. Do you understand? In order for me to engage with the people, I need to tell them what my name is. All right, I need to tell them what my telephone number is, maybe, if I need them to contact me back. So I'm trying to limit the information I'm putting out there in order to procure services. Now, in order for me to execute my right, which is under the Data Protection Act, I feel aggrieved that I'm having to hand over more data that they would need, that they didn't need that information in order to provide me with the service, but now they're asking for more information that like somebody who didn't make the subject access request didn't have to give. That's the angle that I'm coming from, is that you can ask for to identify me with the information that you have on record, but you can't ask me, for example, if I've just given my name and address, and then somebody says to me, in order for us to identify you, we need your date of birth. Well, why do you need my date of birth? Because you don't have that information previously.
Well, you need to go and ask them that, because I can't actually make a decision based on what I'm hearing, from your perspective. You need to really look at everything in the round. And your next course of action then will be, if you remain unhappy with responses, you need to put a complaint into us and we'll pick it up.
Okay. Okay. Thank you, Mr. Turner. You've been very helpful to clarify the matter. I think you've tried your best in order to assist me as much as you could under these circumstances. I'm obviously very grateful that you've upheld my previous complaint, but it meant the fact that I had to still disclose that information, only to find myself now, either it would be easier for me to just disclose that information and deal with the subject access request, but I feel that infringes on my rights. And even though if I want the data, I can hand it to them and get the response that I need within a month. But then I've given data that I wouldn't ordinarily want to give. But in order for me to resolve that, I need to lodge a complaint with yourself, which is going to add a 3-month delay. So it's all about prioritizing, and so therefore I feel what is it obligated, not obligated, but under duress, I am having to give information that I wouldn't have to give because of a policy that they have in place, which is an incorrect policy. And therefore, just like you've rectified one organisation, which is the West Yorkshire Police, every time I'm having to do this, it should be what I would like to see from the ICO is that you've upheld this, that should be published somewhere that I can reference and say, look, this is already, we've already dealt with this once. Does that make sense?
Like I say, a lot of these things are done on a case-by-case basis, and there may be some material differences in this second case, which means that we wouldn't take the same time. I don't know. So that's the first thing. And I think the only other piece of pragmatic advice I might be able to give you is if you feel like you're having to give the information under kind of duress, almost, to be able to get the subject access request dealt with, I can only suggest that you ask them what the retention period will be for the identification documentation.
Okay.
And ask for it to be deleted as soon as it can be.
Yes.
Although you've given it, do you see what I mean?
Yes, I understand. No, that's good advice. Obviously, because my concern is that I don't want to be, profiled. And if they hold information about me that they've procured through me making a subject access request, that should be only there for, and I think that's what the data protection legislation is there for, that the information that you have should be relevant, up to date, and only for the purposes that you're needing it for. So if they need my driving license to make a subject access request, and there's no other way around it, then I can give my photographic identification for that purpose. But then they shouldn't retain that indefinitely.
No.
Yes.
I think most organisations don't. When I've actually dealt with this particular issue, most organisations will have a retention period.
And what will that be, retention period? Normally,
it's the organisation to set any retention periods. What our advice to anyone is you need to look at the necessity of holding on to the data, so it should be as short a period as possible. They need to give a justification to you as to why they're holding on to it for so long. And I would have thought that once they've passed across the data and they're sure it's gone to the right person, then there's no need to continue to hold it, would be kind of my general feel.
Yeah, I mean, just one last point. Sorry.
They should be able to justify. The organisation should.
Yeah. Now, when I'm dealing with just one last point, and I look to end our conversation, the one of the reasons that I have a particular issue or concern is that, like, for example, when I'm ringing yourselves up, I can identify who you are because you've given me your name. And in order for us to have a, fluid conversation, I need to know who you are. And for example, if I'm not happy with your conduct or behavior, I need to identify who you are within your organization in order for me to lodge maybe a complaint about you. I'm just saying that hypothetically. But when I'm dealing with other organizations like this Ministry of Justice, they're saying that they don't need to identify the person that I'm talking to or dealing with. So often what they'll do is they'll just say department, or so I've not given a name. And so it seems highly unfair on from my perspective that here I am expected to hand over my photographic identification in order for you to identify me, in order to deal with the subject access request. But conversely, I'm not even given a person's name that I'm dealing with.
That's down to a company policy. I think it's good practice for people to give their names. I think it's just common courtesy. But that's my opinion. It'd be up to the Ministry of Justice or whoever to decide what information should be given out.
Okay, all right. Okay, well, like I said, let's just bring our conversation to a close. I'm very grateful for your time and your patience and your assistance in providing me with the clarity that I required. Thank you very much, sir. Have a good day.
Thank you. Bye-bye, Mr. Hussain.
Goodbye.